Good evening and welcome to the Harvard Law School Forum. Before I introduce tonight's speaker, I would like to mention that this Monday, November 18th at 8 p.m. here in Ames Courtroom, we will have Tom Wicker, columnist of the New York Times, speaking. The title of his speech is right now, The Politics Before Us. Now for tonight's guest. Arthur Liman graduated from Harvard in 1954 and then graduated first in his class from Yale Law School in 1957. His legal career has been a mixture of private practice and public service. From 1961 to 65, he served as Assistant U.S. Attorney for the Southern District of New York. And in 1965, he served as Special Assistant U.S. Attorney. In 1972, he was the Chief Counsel of the Special Commission investigating the prison uprising at Attica, which resulted in the deaths of close to 50 prisoners. More recently, he's headed the Legal Aid Society. Mr. Liman gained particular national fame when in 1987 he served as Chief Counsel for the Senate on the investigation of military sales to Iran-Contra. More recently, he's headed the defense in the government's high-profile case against Michael Milken, the junk bond financier. Mr. Liman presently is a partner at Paul, Weiss, Rifkin, Wharton, and Garrison. The topic of tonight's talk is, can congressional investigations be conducted fairly? Please welcome Mr. Arthur Liman.
Thank you very much. I envy you for having Tom Wicker this coming week. He was one of the major figures in trying to avert the Attica disaster, and we became friends and have remained so since, and he has extraordinary insights into every subject he speaks about. I chose this topic of can congressional investigations be fair, or I might say effective, also in the light not just of my own experiences in Iran-Contra, but on a more timely basis because of the frustration that everybody had at the Clarence Thomas confirmation hearings, and particularly the last round of those hearings. The subject in my mind was framed by a recent column that Meg Greenfield, a columnist for the Washington Post, wrote for Newsweek. And Ms. Greenfield said that she was very dissatisfied, as everybody was, with the outcome of the Thomas hearings, not just in terms of the confirmation, but she was speaking about the fact that it ended in almost a Rashomon-like mood of nobody knowing where truth lay. And she said that it was unfortunate that this was not resolved the way in which trials resolve issues and divine truth. And I thought about that for a while and realized that Meg Greenfield has probably never served on a jury, and I hope she's never been a party in a litigation, because it is a romantic view, but it is essentially a myth that trials discover truth. Alan Dershowitz's book and movie, Reversal of Fortune, deliberately leave the reader and the viewer with uncertainty as to whether Klaus von Bülow did it or did not do it. The Smith trial taking place in Palm Beach will produce a verdict or a hung jury. But whether the verdict is guilty or not guilty, I don't think that those who watch it, and it will be shown gavel to gavel on court TV, will have a sense that the verdict speaks the truth. They'll form their own opinions, and they'll disagree or agree with the verdict, but it isn't going to be because the verdict has resolved it. It's because you bring to this process your common sense, your prejudices, your intuition, your own. Judge Jerome Frank would say, your whole life's history and experiences. And so it didn't surprise me that a congressional hearing should leave people in doubt as to whether Clarence Thomas was guilty of this charge or not. I think if this charge had been tried before a judge and jury, there would still have been doubt, simply because we do not have any means of resolving issues where it is in an effective way, where it is witness against witness, where the evidence is divided and balanced. And yet, having said that, the fact that this issue was aired the way it was in a congressional hearing left all of us with a very, at least speaking for myself, with a very great sense of disquiet and a sense of unfairness and a sense that this is not the way the system should operate. Trials at least have trappings of due process. And because they have those trappings, because they have procedures that have been developed over the centuries and refined year after year, the verdicts are more easily accepted, even if they do not represent a truth in a scientific sense, but they're more easily accepted than the type of outcome that we saw at the Thomas hearing. And I therefore thought that I would talk about congressional investigations. There has been a great deal of discussion and debate about whether they serve a purpose, about how the process should be reformed, and I ought to talk about it from my own experience in Iran-Contra, because in Iran-Contra I was dealing with a question also for which we were doomed from the beginning not to find an answer that would satisfy anyone. And I say that because the subject of our investigation was really a president. Congress didn't gear up this machinery. The independent counsel did not come into existence in order to investigate a lieutenant colonel. And what we were all looking at, whether we stated it expressly or whether it was implicit, was whether the President of the United States had committed offenses, whether he should be removed from office. I mean, that was the heart of the issue. Everything else could have been handled in a more normal way. And yet, when you're dealing with a President of the United States, you know from your own life's experience that the probability is that the people around the President will be protective. And because they will be protective, the chance of penetrating that cocoon that has been woven around him is very, very remote. You have to have a John Dean in the White House. And when I took the assignment, it was clear that what we had in the White House, in the area that we were investigating, were military officers. Admiral Poindexter was, in a true sense, trained to go down with the ship. And I, at least, anticipated from the day that I accepted the appointment, and I accepted it with reluctance in part for this reason, that Admiral Poindexter would be protective of the President, whatever the truth was. And North also came from that same environment. And McFarlane was also a colonel in the Marines. And even if they had been civilians, there's a natural tendency to equate the President with the Constitution and to defend it with your body. In addition, we knew when we started the investigation that we did not have the kind of smoking guns that existed in Watergate. There was no taping system in the White House, though every now and then somebody writes a story that there must have been. There wasn't a taping system in the White House. And many of the contemporaneous memos that were done at the time, and that would normally give you not just an account of what happened, but give you some kind of access to what people were thinking, to enable you to understand the motives, those all had been shredded, or at least the participants thought that they were all shredded. Some survived, but they didn't all survive, and you could assume that if a decision was made to shred, that the first documents that would get shredded would be the ones that might inculpate a president, and that the ones that you would find would tend to be the ones that they didn't get to and or were sloppy about. So that the odds of cracking the case in a Ellery Queen sense were always against the committee, and yet it was an extraordinarily important thing for us to conduct this investigation, and it was important to conduct it because so much of the events of Iran-Contra had taken place in the darkness of night. There had been so much secrecy. There was so much of a cabal-like environment that it was critical to give the American people a glimpse, even if it wasn't a full glimpse, of what happened and of who the participants were, and to let people make their own judgments. Now, for me, the investigation of this affair dealing with covert operations was really the third investigation that I had conducted into a closed institution. The first was Attica, which was the first investigation into a prison in which the investigators had full access to the prison, the prisoners, the keepers. There had never been anything like the Attica uprising or anything like the Attica investigation before. And we did part of it on television. And Attica had, the Attica investigation, the report by the McKay Commission, had very, very significant effects on reform movements in sentencing and parole, in prison administration, because it allowed people to see for the first time with their own eyes in an electronic era what these institutions were like. I had also investigated the coroner's office in New York, which is understandably a closed institution in which the public knew very little about, and which really needed to have the spotlight put on it. And now I was investigating the whole national security apparatus operating in a covert operation. And in many ways, I think I was misled by the prior experiences, because an investigation conducted by a blue ribbon committee headed by Robert McKay, who was dean of NYU Law School, and with members like Burke Marshall, is a very different kind of body than conducting an investigation for a political institution like the Congress of the United States. We tried in the Iran-Contra investigation to observe some due process. I say some, you never can do it totally, but we tried. There was a sense by all of the members of that committee that the fact that the executive had breached its powers should not give the Congress license to abuse its own, that it would be almost the ultimate irony, tragedy of Iran-Contra if an abuse by one branch just led to an abuse by another. And nobody wanted to conduct a McCarthy-like investigation. And I was appointed to head the Senate committee, and the Senate committee made decisions that were very, very different from the Thomas hearing. The Senate committee decided that it would have a counsel who represented both the majority and the minority, so that there would not be a polarization on the staff between majority members and minority members, and the role of counsel was in the Senate side, was to try to conduct a professional investigation and to keep the hearings from turning into this kind of spectacle that we saw a month ago. And it meant, therefore, that I regarded all members of the committee, from left to right, as my clients. And it meant that there was a covenant that they made that they would not try to demagogue it up during the hearings, and that we would try to stick to the issue at the hearings of what happened. Now, we couldn't carry that out, and I'll explain why, but that was what the goal was. Let's not have hearings on whether Contra policy was good or bad, because if you got into the issue of whether you should support the Contras or not support the Contras, that all that you'd have is speeches. And you'd never be able to have hearings that dealt with the facts of what happened. It was too divisive an issue. Indeed, on the Senate side, a majority of the members of the Democrats on this committee, as well as all of the Republicans, had supported Contra aid and had opposed the Bowen Amendment, so it was hardly even a fair split. So the idea was, let's try to do this investigation as fact-finding and avoid the more partisan issues that would polarize a committee. And that was an important agreement that I think you have to have if you're going to conduct hearings in a way in which people have some sense that that people care about what really happened. Congress isn't set up to be a court. There's nobody there who can sit in the middle and rule. And therefore, the model for a congressional investigation, I would say, is more the inquisitorial, the magistrate method of the continent than the adversarial system of Anglo-Saxon jurisprudence. And that's the way we looked upon this investigation, that every witness would be subjected to examination and cross-examination, and if Oliver North said that he told the president, he'd be subjected to as much cross-examination as if he said he didn't tell the president. It was to be straight down the middle. Now, it didn't work that way, I'll come to that, but those were the aspirations of this investigation. And it doesn't happen by accident. Senator Inouye, who chaired the Iran-Contra hearing, was a veteran of the Irvin Watergate investigation. Now, the Irvin Committee in Watergate is regarded as being a very, very successful congressional committee. Many people credit it for the ultimate impeachment of President Nixon. What was not known to anyone other than those people who are on the inside, like Inouye, was that it was an extraordinarily partisan group. The majority staff and the minority staff spent most of their time spying on one another. They spent so much time spying on one another that they never issued any subpoenas or requests that would have called for tapes, and that they discovered the tapes toward the end of the investigation by accident. So that the adversarial method that was typical for congressional investigations almost led to the tapes not being found and produced. It was the result of a witness volunteering their existence in public hearings, and Inouye thought that the hearings led to the glorification of Sam Ervin, but that they really weren't designed to get at whatever you could. The other decision that was made by the Iran-Contra committees was that the investigation should be done privately, and that the public hearings really should be held to exhibit what you had found, much the way a trial exhibits the evidence that each side has already discovered and marshaled, that you weren't going to use public hearings to put witnesses on totally green and just wander around, and that we shouldn't have an investigation in which you give each member of the committee, the Senate or the House, 10 minutes, and then the next member gets 10 minutes, no questions get followed up. The result is that you end up with more confusion than what you started with. And the theory was initially that the staff should do the whole investigation in executive session, do it privately, and that at the end of that process there would be public hearings, and that the members of the committee themselves would conduct the hearings. You'd appoint one or two Democrats and Republicans for each witness, a system that was tried in the Clarence Thomas hearings, but which didn't work there, and which was abandoned in our investigation because the subject was too complex, and the members of the committee realized very quickly that there was no way that they could conduct a coherent examination of the witnesses. They were better off coming in and asking pointed questions on the basis of what they had already heard than to try to do an examination from scratch. And so that was the way in which we set it up. It was set up, in that sense, the way in which you would set up a trial. Do your preparation first, examine your witnesses in your office, and then call those who have something important to say and lead them directly into relevant areas of testimony, develop the testimony in a thematic way so that the public can understand it, and try to have hearings that would serve a didactic purpose and not just a political purpose, and that, I think, was the goal. The other decisions that were made by the committee that are taken for granted today, but I can assure you that any student of congressional investigations would tell you it was an exception, not the rule, was that we would not call any witness solely for the purpose of having the in public session, solely for the purpose of having the witness invoke the Fifth Amendment. Senator McCarthy and others of his generation, Senator Munt, had the House Un-American Activities Committee had perfected to an art this business of calling witnesses in public sessions, knowing that they were going to take the Fifth Amendment, and then asking them loaded questions and just getting the Fifth Amendment responses one after another, so that here you could have said, you could have put Poindexter on and said, "Now, Admiral Poindexter, isn't it a fact that you told the President all about the diversion? I refuse to answer on the ground that the answer may tend to incriminate me. That isn't it true that the President ordered you to cover up the diversion? I refuse to answer." And you could have done that for an hour, and by the time you finished, half the country would have believed that his answers really were acknowledgments that the President was guilty, which he may have been, but that's what he was saying. The other half would have been at your throat for using the McCarthy technique. And the committee said, no, it didn't want any part of that. So every witness who was called in public session and who planned to take the Fifth Amendment had already received an order of immunity, and they just went through the initial question in which they had to invoke their privilege, and immediately after that we would give the immunity formally and the testimony would be given. We respected attorney-client privilege. We respected doctor-patient privilege. I didn't see the difference between the Ellsberg break-in and demanding the medical records of North for his treatment by doctors or psychiatrists in the Pentagon. He was entitled to his privacy, and the right wing, which has adopted him as a hero, may not believe in the right of privacy, but we were not hypocritical, and we did believe in the right of privacy, and we respected those things. And so there was an effort at trying to be fair. The process broke down with us the same way it broke down in the Clarence Thomas hearings. What happened in the Iran-Contra hearings was that the Senate's hearings had to be merged with the House's hearings. The House did not have this kind of agreement among its members that they would try to conduct the hearing in a less partisan manner. For the House committee, it was business as usual. And that meant that for the Republican members of the House committee, this was a soapbox to blast the Congress for having adopted the Bolin Amendment and an opportunity to speak about democracy in Nicaragua, and that they were going to engage in that kind of speech making at every opportunity. And once they began doing it, it meant that members of the Senate committee, like Orrin Hatch, had an irresistible temptation to join in. And those of you who watched the Clarence Thomas hearings and saw Senator Hatch really know that he's very, very good at making these kinds of speeches. And so that once our hearings began, the agreement fell apart. And there was a degree of politicization that we wanted to avoid. It wasn't overwhelming. Representative Hamilton and Senator Inouye try to control it, but it did have an effect on the hearings, and it blurred what we were trying to accomplish. The other thing, of course, that happened was Oliver North. Oliver North came to these hearings and he just sort of electrified the country. Now, I tell you that as a trial lawyer, what you would have done with an Oliver North at a hearing was to let Oliver North talk for a day and 2 days and 3 days and 4 days, and by the third or fourth day it would have been like Captain Queeg. There would have been a self-destruct, and I'm not. I don't mean this in a mean way, because I think Oliver North has the capacity to believe everything he says, but people would have started to see through it, and they'd ultimately start laughing at it. But the object was to keep him on the stand long enough. And what happened, and incidentally, his lawyer, who's a very good lawyer, Brendan Sullivan, who you all saw, knew that this would happen to North if he was kept on too long. He bargained for us to keep him on for no longer than 5 days, but we could have kept him on for more than 5 days. We kept him on as it is for only 3.5 days. And what happened was that we divided witnesses between the House and the Senate. The House counsel had North, I had Poindexter, and the House counsel was a very able lawyer by the name of John Niels, very, very able. And John led off with Oliver North, and he was taken by surprise, and North kept making these speeches. Now, the speeches, if you just read them, were extraordinary admissions. They're no different from the book today, which has been billed as having lots of discoveries. His book is essentially a rearrangement of his testimony to put it in a different order. But he made speech after speech, all of which had an effect of saying, I am the patriot, that I was fighting for democracy. Congress was a leaking agency. Congress was frustrating efforts to achieve democracy. I am the fall guy. Congress is now making me into the scapegoat. And the telegrams started to pour in. And they poured in, and they poured in. And in fact, they were given a subsidy to come in because Western Union, seeing a good thing, decided that it would provide a special rate for anyone who sent a form telegram to Oliver North or to the committee saying we support Oliver North, and if you wanted to send a telegram supporting the committee, it was 4 times the rate. And so I guess justified on volume discounts. The result was that this political body, the United States Congress, was there getting this mountain of telegrams saying, why are you picking on Oliver North? Why don't you vote him the Congressional Medal of Honor? And John kept going and going and going, and I was waiting for my turn, and by the time my turn came, we had a committee of 11 members, right, Sam? Sam Hirsch was on my staff, and we had a committee of 11 members, and then there were 15 members of the House, and all of the Democratic members and some of the moderate Republicans were audibly praying, please, Arthur, don't cross-examine him, get him off the stand. I mean, they were almost literally in trauma that a confrontation with Oliver North would lead to all of them losing the next election. And the result was that I got him off the stand. I covered what I wanted to do with him, and then I had a whole volume of questions which had been prepared for the members to ask to fill in the blanks. And as I recall it, not one member of the committee, this group of 26, was willing to ask him a question. They all made speeches. Most of them made speeches saying that he was a great hero. It's just too bad he didn't understand the Constitution. Those who were on the Democratic side said he didn't understand the Curtis Wright decision, as if that's what the hearings were all about. And so Congress backed off in being able to have a fuller airing of what Oliver North had to say, and he left really at the height of his testimony. And I therefore could sympathize with those of us who felt that the Clarence Thomas hearings were unfair to Anita Hill, in that I think that the same kind of fear gripped the Democratic majority of that committee. I'll give you my analysis of it. I don't know whether anybody on the committee is capable of this kind of self-analysis himself. I don't have to say himself or herself in this case. Those like Senator Specter, who saw their role as the defender of Clarence Thomas, had no fear of being embarrassed. They had absolutely no fear of being embarrassed because they knew that whatever the evidence was, Clarence Thomas was going to go to his grave saying he didn't do it. And so they therefore felt very, very comfortable in conducting a vigorous and, in my opinion, an unseemly examination of her, making speeches. It was not, whatever people may say about our investigation, we never descended to those depths. We try to maintain principle, and we kept it in a what I think was a dignified way. That no amount of provocation, and there were provocations directed at me personally, could lead me to respond in kind. And this committee on the Republican side did things that you wouldn't do in magistrate's court, because if you did it in magistrate's court, the jury would find against your client. I mean, it was there was almost, in my view, a deliberate intent not to understand what she was saying on some subjects, and then representing what she said as being perjurious when it wasn't. The Democrats, on the other hand, were seized with fear that if they defended her too strongly, and if it turned out that there was something in her past that would come up, that she was a fantasizer, that she had made charges against other people there. They didn't have control of the witness. They didn't know that there was a fear of the unknown, that they would be out on the limb. And so they therefore occupied sort of a neutral role. They were judicious in their questioning. And when you had this kind of self-restraint on one side, while you had bullying on the other side, the outcome was almost inevitable. And there were some great moments when Biden did rise to the occasion in one speech he gave at the end. But the notion that a candidate for the United States Supreme Court should have been allowed to virtually unchallenged make statements about conspiracy against him, and that itself should not have been a subject of concern and questioning by the members, was, to me, sort of the ultimate proof, the demonstrative evidence of the failure of the process of that committee. They also didn't ask follow-up questions with respect to her. None of us knows whether she acknowledges that Clarence Thomas went to her apartment or didn't go to her apartment. It's sort of a basic question. If you're going to go into these hearings, at least answer that question. But it wasn't answered. And the result was that once the polls came in, and particularly the polls in the southern states, and showed that the constituents there wanted Clarence Thomas confirmed whether or not he was guilty of sexual harassment, the hearings result was foreordained. Now, why did it have to be that way? Well, I think that, and here there's a degree of speculation, the proper way to have conducted this aspect of the Clarence Thomas hearings was in executive session. In fact, those hearings got all convoluted. In public session, they didn't insist on answers to questions which they should have had the right to have before confirming somebody for life. And this was not a blank slate like David Souter. This is a person who had spoken on a subject, and you were, since he had spoken on a subject, entitled to find out whether it still reflected his views, and if it didn't reflect his views, in what way they had changed. Those questions were all off bounds. They weren't asked, so that the public sessions didn't ask the questions that were relevant for a confirmation, and the public sessions explored subjects that would have been more comfortably exposed, at least in the beginning, in private. And we stripped away her privacy, and we stripped away the privacy of a lot of other witnesses, and we were racing against a clock, and we had the public opinion polls, and we had inept questioning, and we had no staff and no professional examiners except a former DA on the Republican side, and it was really a bad show for Congress. Now, let me come back to our hearings. I am very, very mindful of the fact that as a result of our giving immunity to Oliver North, he had his conviction dismissed, and therefore the question is often put to me, was it worth it? When you're a participant in the decision to give immunity, you become introspective as to whether all you're doing is rationalizing your own mistakes. I don't think I'm doing that. I think it was worth it. I think that what I would say to you is that if the choice was whether Oliver North should have had 1,200 hours of community service, which is what I think he got, or 800 hours, and Poindexter should have gotten a year in jail, that's one choice. And as part of that choice, we would not have had the picture of what was knowable about Iran-Contra until 5 years after the event, until Oliver North wrote his book. Then I say that it was better to air the subject at the time, and it was more important that we try to find out at the time, in a public forum in which people could have confidence that they were at least seeing the witnesses and being able to form their own opinions as to what happened and whether the president was responsible. And we did not prove in an impeachment sense that the president had directed the cover-up, or that he was the person who was knowledgeable about the diversion. But those who watched television and watched Poindexter's explanation of why he didn't tell the president could not have easily believed Poindexter's story. And if you accept the fact that some stories have to be left, at least in part, to inference, then I think that the American people did get from our hearings that story. I at least came away from the hearings convinced that the president was responsible. And before we had those hearings, the public record of Iran-Contra had been written by the Tower Board. And the Tower Board was an accomplished commission It operated behind closed doors and it couldn't give immunity. And the picture it portrayed, that it presented, was one of a distant, remote president whose biggest mistake was appointing Donald Reagan as his chief of staff, George Shultz as his Secretary of State, and Cap Weinberger as his Secretary of Defense, and who did not know what was happening. The picture that emerged from our public hearings was that when it came to the decision to sell arms to Iran or to continue to arm the Contras, he was a hands-on president. It was his policy. It was his decision. And even though Poindexter said he never told him about the diversion, he also said that was consistent with his general marching orders, and it was. I think he told him about the diversion, but that's irrelevant. We didn't prove that. I think that the Iran-Contra affair was Ronald Reagan's affair. He was at the center of it, and people who watched the hearings understood it. And indeed, the sympathy for North was sympathy because he was seen as a fall guy. And when Oliver North said in his book, and it got headlines, that he believed that the president knew about the diversion, people forgot. That's what he testified in our hearings, that he believed that the president knew about it. Before North testified, there was a mythology that he is a lieutenant colonel who went off on an escapade on his own. He was the loose cannon. And he said no. Everything he did was authorized by McFarlane and Poindexter. And Poindexter confirmed that. And so we got a great deal of the story out. And if you believe that there are some offenses in government that aren't defined by the United States Code, if you believe that the courts are not the answer to every abuse of power in the way in which we govern ourselves, if you believe in what Brandeis said so many years ago, that in a democracy sunlight is the best disinfectant, then I believe that our hearings were the only disinfectant such as it was. Today, 5 years after the story of Iran-Contra was broken by that Lebanese newspaper, the independent counsel's work is still not finished. His report is probably a year from completion. By the time the report is issued, the people are going to be bored with what happened. There will be a footnote in history. And given the fact that what we were dealing with, in my opinion, was not so much a war against the Sandinistas, but a war against Congress, it was imperative that if Congress took seriously its role in foreign policy, that it conduct its own investigation, that it present publicly what happened, and if the price, as the D.C. Circuit said in a ruling that's unprecedented in its breadth, if the price was that Oliver North will have his right to vote restored, then so be it. I think that in a difficult area, in a matter where you have to do balancing, that the scales tipped in favor of disclosure. I would say that those who take the opposite view often assume that we would know exactly today what we do know without the immunity. They just take for granted things that came out only because of the grant of immunity and then say, why did you give it? And it's easy to understand why, because it's hard to separate what the sources of your knowledge are. And all that I can say to that is that if we had frozen our knowledge with the tower board, or if our knowledge was only what you got under the very restrictive rules of evidence in the North case, you would have known a lot about the tin cup in which he allegedly kept his money. You would have known a lot less about how this affair happened. And Poindexter, I would remind you, has yet to testify publicly in any proceeding but our own, because he refused to testify at his own trial. So that's, those are my sort of off-the-cuff views on congressional investigations. There are lots of things I would have done differently. There are lots of things that I'm sure others who come after me and conduct these investigations will do differently. They will always have a political restraint. And another word for political restraint, I guess, is democracy, and that the Congress has to be responsive, and you have to accept those limitations. I thank you, and I'd be happy to take your questions. On any subject. Questions? Yes.
Mr. Liman, one of the more interesting people to appear during your investigation was a graduate of this law school, Elliot Abrams.
Right.
I wonder if you have any reflections on how the old Elliot Abrams affair, I guess, which finally ended last month when he pled guilty to 2 misdemeanors.
Well, I don't know how many of you remember his appearance at our hearings. He was shredded at our hearings for the very dissembling that he was indicted for. And one of my reactions is, what's wrong with our criminal justice system if 5 years after we knew that he had engaged in this conduct, a decision is made to indict him? Now, he could have been indicted for these events 5 years ago. The other aspect of it is I think I'll be a little more introspective about it myself. I believe that virtually everybody caught up in the Iran-Contra affair was a casualty of a decision that the president made. And that doesn't mean that they don't bear responsibility for it, but it means that you have to evaluate what they did in that context. Presidents, whether they're Democrats or Republicans, have enormous power. They inspire extraordinary allegiance. People who work for presidents confuse them with the Constitution. There are exceptions. Cy Vance, when he disagreed with Carter, resigned. Clark Clifford stood up ultimately to Johnson on the Vietnam War. But they were powerful people. Most people who work for presidents have almost a groupie attitude. It's the only president they've ever worked for. He's their president. He gives them power, and they exercise no independent judgment. When this president decided that he was going to publicly proclaim that he was adhering to the Bowen Amendment, while at the same time circumventing it secretly, and when he announced that he was following a policy of not trafficking with terrorists while selling them arms secretly in order to get hostages back, he made it almost impossible for the people around him to be honest with themselves, let alone with Congress and with others. Alan Fires, who's the CIA official who pled guilty recently and is cooperating with the independent counsel, testified before us that he felt that he was in a giant nutcracker. We had military officers, decent people who worked in Central America, who were torn between allegiances to the White House and their own sense of it being wrong to lie. But when you have a secret policy, then of course there's going to be a big lie, unless people have the courage to say, we won't talk about it. And when they're called before Congress, as Elliott Abrams was, to have the sense enough to say, I'm claiming executive privilege. Instead, every one of the officials who came before Congress before the investigation, before the story broke, dissembled. Now, I don't think that Oliver North, if he had not worked for this administration, would have been a lawbreaker. I don't think that he had that kind of flaw in his character, and certainly that's not true, of Poindexter. Poindexter would have served out his career in the Navy in an honorable way. He would have headed the Sixth Fleet. He would have retired. He's a man who refused to wear his uniform when he testified, because he took the Annapolis Honor Code, and the first commandment in the Honor Code is thou shalt not lie, and he somehow had convinced himself that when he wore the uniform, he was a naval officer and therefore bound by the code, and when he didn't wear the uniform, he was a political official in the Reagan administration and free to do whatever politicians do, which may include lying. And you never could get Admiral Poindexter to wear his uniform when he testified. I had him testify 6 times privately. I could never get Admiral Poindexter to wear his uniform. Admiral Poindexter will go to his grave and see his maker and say, I never lied in uniform. We used to give nicknames to these officials, and my nickname for Admiral Poindexter was Billy Budd, because I just felt that he was going to go off the gangplank, thanking the captain for having given him the opportunity to serve, and that you took people who chose a life of public service or military service, which is a form of public service, or CIA, and who ended up destroying their careers, not being able to face their wives and children, having all of this disgrace because of a decision of one man that he would show his contempt for Congress in the way in which he conducted his policies. And incidentally, I saw the Iran-Contra affair in a much broader context. I mean, to me, what happened in the Iran-Contra affair was not much different from impoundment of funds that had been appropriated and authorized by Congress. It was not different in my mind from saying, well, Congress won't abolish the Legal Services Corporation, so what I will do is that I will make interim appointments of people who are hostile to the Legal Services Corporation and put them on the board of the Legal Services Corporation. And there was an absolutely total contempt of Congress in that administration. And the functionaries, in many instances, got caught in the middle. Some didn't. Abe Sofair, and I don't remember whether Abe went to this law school, didn't. He threatened to resign. George Shultz didn't. But a lot of the others did, and they are casualties of the Reagan policy. And I can understand the rage of an Oliver North that he ventilates in this book, that the president has yet to do what you'd expect the commander-in-chief to do. The statute of limitations has run, and said they were following my orders, let them off, it was me. I mean, you have to ask yourself, I mean, what kind of administration was this in which the subordinates were expected to serve the prison time? And I reread Oliver North's testimony after I read his book, and when I questioned him in the little time that I had, what he said was that I was prepared to be the fall guy for political purposes. When they announced that it was going to be a criminal investigation, that was when that role ended for me. And I think that, it was extraordinary. I mean, when Oliver North initially resigned, Poindexter indicated he knew nothing about the diversion. He had authorized it. I mean, they were all prepared to let the lowest person take the responsibility to keep it away from the president. And so, when I think of Elliott Abrams, I also look upon him as a person who has an element of being at the wrong, working for the wrong president at the wrong time in what happened to him. But I do believe very much in in the rule of law, and I believe that a graduate of this law school ought to know that you don't lie. Yes.
I'm watching the hearing, and that sometimes one does think that the questionnaires were trying to make the country go, wow, as far as goodness, this guy is guilty, Oliver North. And when he responded, it seemed like it made an impact that no, I'm not guilty at all. And I'm wondering how much effect it had on that sensation, on that impression, the fact that the things that were supposed to have been done, the arms for hostages and also the back in the Contras, were not necessarily conceived by most people as evil in themselves. It wasn't like saying you went and killed somebody, so that people would not understand that necessarily as being, oh, how evil this is.
Well,
and yet the speakers or the senators or whoever, at the time that they questioned, they seemed almost to be expecting that people would be just shocked by his conduct.
Well,
but I don't know if there was a recognition that maybe most people do not understand the subtleties of the policy violations that might have taken place.
Well, I think that was part of the problem when the hearings turned into a debate over the policy. If we could have presented this the way a documentary filmmaker could make a documentary, then what I would say to you was that you can disagree with a law, but if you're the president or you're in the administration, you're sworn to uphold it. And that's why I didn't want to get into whether the Boland Amendment was good policy or bad policy. It was the law. And there are lots of laws I disagree with, but they're, that you're obligated to enforce them and carry them out. And they did just the opposite. Now, you're right. When it came to the Boland Amendment, the country was evenly split. Every poll showed that the country was evenly split on the Boland Amendment. And therefore, I think there was a sense, well, so what, that people circumvented the Boland Amendment. There was a different attitude about selling arms to the Ayatollah. I think there's probably 80% of the people were appalled by it. And I'll tell you where I got that information. The President of the United States did polls every week on the Contra policy, and he was frustrated by it, and he would confide in his diaries his frustration that he couldn't understand why he could not, with his weekly radio addresses, get a majority of the country to support the Contras. Now, when I say evenly split, I'm not trying to be precise whether it's 50-50. It could have been 35-65 one week, 40-60, 55-45. The Congress itself mirrored the vacillation of the country on this issue. It was not an issue that in which there was a clear consensus in the country.
Polling that as much as 70% of the people in this country were sympathetic to a policy that was reflected in the Boland Amendment.
Well, it depends how you frame the question. You see, if the question was, do you want to get into another Vietnam, then it was probably 90% that were for the Boland Amendment. If the question was, do you want to withdraw the support from this ragtag band of Contras, then you got a percentage that was quite different. It was a matter of what were you doing and how people saw, whether people saw it as a first step or as a last step. But the fact of the matter is that if you look at Congress in some ways as a barometer of public opinion, the Congress was constantly going back and forth on the Boland Amendment, and it only lasted a little over a year. I mean, by September of 1986, we were back to military aid. We were earlier back to humanitarian aid, which Senator Kennedy pointed out was a euphemism for providing field supplies, rations, uniforms. So it was an issue on which I think that there was not a consensus. But my point wouldn't have mattered in terms of whether it was 70%, 30, 60, 40. The fact is that it was a law. The president didn't do what Roosevelt did. When Roosevelt wanted to sell destroyers, he did it openly. He said, I'm exercising my presidential prerogative. When Truman seized the steel mills, that here you had a president who purported to be complying with a law that he signed. He didn't veto it. He signed it. And at the same time was working underground as if it didn't exist. And I think that was what's intolerable in a democracy. And that's what gives you the fear of, is there a secret government, and can you trust government, and do laws bind the executive branch? The other part of your question was, were people bothered by things? If you could have presented that documentary, I think people are bothered by a cover-up. I mean, that's incidentally true, just in even small events, normal criminal cases. It's always the cover-up that's worse than the underlying event. And the cover-up here was revolting. Yes, sir.
The committee didn't get to the president because of a political position or because of legal.
No, because no. No, I was just talking about the more or less the choreography of a hearing as to why, in the case of Oliver North, the committee could not press forward with all of the questions it should have. The reason that the committee did not get to the President of the United States was that the evidence did not exist for us any more than it exists for the independent counsel who's had 5 years to develop his case. The fact of the matter is that there is not a single document that inculpates the President, and that the only witnesses who could have inculpated him all said that he either did not know or that they did not tell him. So it was a case in which you did not have the evidence. Now, in a parliamentary system, the fact that the President was so heavily involved and that you could draw inferences about the fact that he set in motion the whole process would have been enough to bring the government down. We don't have a system of votes of no confidence, as you know, and so in order to bring a president down in this country, it has got to be based on an impeachment process of high crimes and misdemeanors, and no matter how you define that, it was something more than either we or the independent counsel could establish. The evidence was just not there. And unless we were going to rewrite the Constitution, you could not possibly have brought the impeachment proceeding. Poindexter, when he covered the President with his body, ended that whole inquiry. There was no way of getting past him. No. There's no evidence now. All of the roads led to Poindexter. I mean, North, in his book, in which he, as I say, he ventilates his anger, says no more than what he said in our hearings, which is that he always believed the President knew, but he never told him. Nobody ever said to him that they had told the President. It was an assumption on his part that the President would have been told. And so he never met with the President alone, and the President was never told in his presence. The only person alive who could answer that question is Admiral Poindexter, and he has answered it, and he's not going to change that testimony. And his answer has been that the President was not told of the diversion, nor did the President order a cover-up. So there was no John Dean in this administration. Yes?
Some of the critics of the hearing say that one of the most important problems was that the goal of the hearing was to get the President to say find out what really happened.
No, I mean, I think that there's more criticism that I've heard the other way, that we didn't have a thirst to get the president. I think that there was an honest effort to try to get the facts, but you have to say, what are the facts? I mean, were we conducting an investigation into everything that every person who was in government did in the Iran-Contra affair? And the answer is no. If you don't have a select committee of Congress that conducts that kind of investigation. What we were doing was we were conducting an investigation into the central events with a focus on whether the President of the United States was the person who was responsible for the cover-up, for the diversion, and for events that weren't criminal but were significant, such as the decision to sell arms to Iran and the decision to continue to support the Contras. And it wasn't an effort to get the president, and there was I did not detect on the part of any member of that committee a hunger to get the president. He was immensely popular, and I detected an enormous sense of self-restraint about whether to how far to go. But there were no restrictions put on me, and I can assure you that if Admiral Poindexter or North or a document or somebody else had inculpated the president, that there would have been an impeachment. We saw hundreds of witnesses. We examined hundreds of thousands of documents. We did a computer dump where you got bits of words and sentences. The independent counsel described the president in his first indictment of North as a victim, somebody who was betrayed by North. He's never been considered a target of the independent counsel's investigation because he found no more evidence than we did, and he had more power than we did because he had the power to indict and to use that power to obtain cooperation. There are some events that you just have to leave for history, and that you can call all the witnesses in the world and you be the judge. Do you believe that a professional naval officer who never in his life put his commander-in-chief at risk or his commander at risk would all of a sudden make the momentous decision to authorize a diversion and not get permission first? Do you believe that he would do that knowing that if the diversion came out, that the whole administration could be rocked with scandal? And do you believe that if it was as simple as that he would have taken the Fifth Amendment from day one? Here's a admiral who, as soon as the scandal broke, the first thing he did was he tore up the only copy of the presidential order that described the sales to Iran as an arms for hostage sale. And when asked by me as to why he did it, he said to protect the president. Protect him from what? To protect him from political embarrassment. So clearly Admiral Poindexter saw this, said he saw it as one of his duties to protect the president politically. And if he had told the president, he would have said he didn't. And of course, if he didn't tell the president, he would say he didn't. And you have to make your own judgment as to whether you think this military officer did this on his own. The person who knew him best, McFarland, said under oath, just volunteering his opinion, that it was inconceivable that he could do it on his own. Oliver North clearly, not just by his words, but by his actions, indicated that he believed that Poindexter had told the president. So, if Poindexter didn't tell the president, he took on more responsibility for an act that was stupid than he ever did for any act in his whole tenure there. But, you know, you have to make those judgments that there wasn't the proof to impeach. Yes?
We like to select our debates, last question, that everyone is invited to reception.
This leads up to the piece of the question I was going to ask. Firstly, I was really particularly disgusted by the disposition of the case. And I was...
How was it, you're not talking about Felix Rodriguez because he wasn't indicted. You mean Joe Fernandez? Well, he wasn't indicted because I guess that the independent counsel didn't feel he had a case. He did indict. What? No, let me just... you're thinking of something that you have a right to be disgusted about, but I think you have the wrong name. Okay? There was a CIA station chief in Costa Rica who was indicted in Virginia by the name of Joe Fernandez. And his case was dismissed because the Attorney General refused to release the classified documents. Look, I believe that well, I don't... Well, that's a big question, but let me just answer it first, and then I'll get to you second. I think that the Justice Department under Thornburg was an intensely political Justice Department, and I cannot understand a principled basis for withholding the records in the Fernandez trial. That isn't to say that I necessarily agree that the way to have gone about it was to indict some station chief in Costa Rica while everybody else is getting away with it. But the fact is, he was indicted, and the Attorney General withheld evidence and therefore killed that indictment. And I thought that was an absolutely outrageous decision. On the October surprise, you know, you've read the New Republic on it. You've read Newsweek. My view on it is this: that clearly Casey had a motive to do something to defer the release of the hostages. But that's like, again, an Agatha Christie story where everybody from the butler on up has a motive to commit the offense. The question is whether Casey had the opportunity to do it. Did anyone from the Iranian administration in power, somebody with authority, ever make contact with him so that he could make a deal? And there, the proof at the very best is equivocal, And, at worst, it's either incredible or dubious. The first person to challenge the proof was a person who had no motive to challenge the proof. It was Lloyd Cutler, who was President Carter's counsel, and who wrote a very, very forceful op-ed piece in the New York Times taking apart the sick theory. My sense of it is this, and I don't know, the only thing I know about it is because it was outside of our mandate, is that we took a peek at one little part of it because it was irresistible, and that is that one of the Iranians passed word that George Bush was in Paris on a particular date, and that's when the October surprise deal was made. And so we got the Secret Service records, and we also got the records of what he was being covered on that day by journalists. And as I recalled it, the date that was picked was a date that was blank in the official calendar, but it was not a date that he had disappeared. The journalists were there covering him, the Secret Service was there covering him, and he wasn't in Paris. And so, that was dismissed. Now the theory has shifted to the fact that it wasn't George Bush, but that it was Casey in Madrid. We didn't give immunity to Gabanafar or to any of the Iranian middlemen, not just because they failed to pass a single question on a lie detector test, because I don't really believe lie detector tests, but because the stories kept changing in our own area all the time, and we didn't find anybody that you could trust at all. And I think that if the House and the Senate have been quietly, certainly the House, have been quietly looking at this subject since Gary Sick wrote his piece. And it's inconceivable to me that if they found something that really stuck, that they wouldn't have gone forward with this investigation more quickly. They seem to be going forward with it very, very reluctantly. And my guess is that it will be an equivocal result, and one in which one thing that I would feel confident of is that if Bill Casey had had the opportunity to delay the release of the hostages, he would have done it, and he would have boasted about it, because he would have elected a president by doing it. But I just don't see the contacts that would have enabled him to do it.
Just watching the inauguration and seeing, just within minutes.
There's an equally